Hi, hello everybody. This is Uma from Success Law Classes. Today we are going to practice test series for AIB examination. So the first question under this series is the section 12 of Hindu Adoption and Maintenance Act 1956 deals with. So option A is right of adoptive parents to dispose of their properties. Option B is effects of adoption. Option C is presumption as to the document relating to adoption. Option D is cancellation of adoption. So the correct answer is B, that is effects of adoption. So section 12 of Hindu Adoption and Maintenance Act 1956 deals with effects of adoption. Under this section 12, an adoptive child shall be deemed to be the child of his or her adoptive father or mother for all purpose with effect from the date of adoption, and from such date all the ties of the child in the family of his or her birth shall be deemed to be served and replaced by those created by the adoption in the adoptive family. So this is with regard to first question. Then coming to the second question, which of the following categories of cases will not be entertained as public interest litigation? Option A is family pension. Option B is petitions from right victims. Option C is neglected children. Option D is landlord and tenant matters. So the correct answer is option D, that is landlord and tenant matters are not entertained as public interest litigations. The Supreme Court has issued set of guidelines according to which the following matters will not be allowed as pills: landlord tenant matters, service matters, and those pertaining to pension and gratuity. Admission to medical college and other educational institutions, petition for early hearing of the cases pending before High Court or subordinate courts. So this is with regard to second question. Coming to third question, who is known as father of public interest litigation? Option A is Justice A.N. Roy. Option B is Justice Y.B. Chandrachud. Option C is Justice R.S. Pathak. Option D is Justice P.N. Bhagavati. The correct answer is option D, that is Justice Bhagavati has been called the father of public interest litigation in India due to his contribution to public interest litigation jurisprudence. Justice Bhagavati was Chief Justice of India from July 12, 1985 to December 20, 1986. Then coming to the fourth question, which of the following is not a real purpose of public interest litigation? Vindication of the rule of law, facilitate effective access to justice. Option C, meaningful realization of fundamental rights. Option D, getting famous and making wealth. The correct option is answer D. Here the purpose of public interest litigation is not getting famous or making wealth. So this is with regard to fourth answer. Then coming to fifth answer, in Usnera Khatun and others versus Home Secretary State of Bihar 1979, dash emerged as a basic fundamental right. So option A is right to speedy justice. Option B is right to clean environment. Option C is right to free legal aid. Option D is none of these. So the correct answer is option A. In India, the concept of speedy trial is introduced in Husnera Khatun and others versus Home Secretary, State of Bihar, 1979. In this case, the Supreme Court done a broad interpretation of Article 21 and stated that the right to speedy trial is a fundamental right. Speedy trial is an essence of the criminal justice. Delay in trial constitutes a denial of justice. Means if there is a delay in trial, then it is denial of justice. So this is with the practice questions. 5 practice questions we have practiced. Thank you all. Please subscribe.